marginalized groups are under attack as the Trump administration works
to erase history rather than make it, to erase fairness, equality, to erase justice itself.
For his
just saying something and not giving any facts to back it up. I'm getting so tired of it.
Trump blamed the Biden administration for
people are going to die.
Russia's invasion.
But you can't ask the question, well, how do you figure? Explain to me how people are going to die, right? I'm sorry, you're concentrating.
Well, is this supposed to come on? Feeling well.
I don't know, I can never see.
Justin Timberlake sharing a statement with fans online that he recently found
I never
out
see
he has Lyme disease, saying in part, quote, "When I first got the diagnosis, I was shocked for sure, but at least I could understand why I would be on stage and in a massive amount of nerve pain, or just feeling crazy fatigue or sickness." The Grammy winner has been on his Forget Tomorrow World Tour since April 2024 and performed his final show Wednesday in Istanbul.
Fox's Monica DeLuca on Wall Street. Stock futures are down big before the opening bell, more than 300 points for the Dow. I'm Dave Anthony, and this is Fox News.
And good morning. Glad you're with us. And we are here with Stan Pierchoski and Bulletproof Estate Planning.
Good morning, LB.
Good morning.
That is correct. We are here for Bulletproof Estate Planning. Let me just turn my headphone down a bit. Feels a little hot. That sounds, well, make it hotter. Yeah, that's the wrong way to turn it. Okay. Now let's.
That better?
That sounds better.
All right.
Okay, yeah.
All right.
So yeah, it's Friday again. I mean,
yes.
we do this every Friday morning, and it seems like it gets here pretty quick, and it's usually one of the fastest hours of my week.
Yeah.
You get started talking, and next thing you know, it's 9 o'clock. So, you know, we have to do something. We might as well be in here doing this rather than outside in the sun.
I had rather be in here doing this than.
Although this week's supposed to be a little bit of a break. I was looking at the forecast. Now that's the forecast, of course, and it looks like they're not in the 90s anywhere, but we're in the 80s. Actually, there's a couple of highs that are 80 or 81.
Ooh.
At 10, 12 degrees make a big difference.
It will make a big difference.
And it'll probably only last for about a week, but we'll take what we can get.
Oh yeah, it's.
Because August will be pretty hot, but toward the end of August, beginning of September, it starts to give up the. The telltale sign is when the overnight lows. I mean, when the overnight lows start getting lower, like out of the 70s. That's then the days that get hot, it's like you may have a 90-degree day, but like it goes up to 90, and just about as soon as it gets to 90, it turns around and starts heading back down. It doesn't have the staying power. Like now, it gets to 90 degrees at 9:30, 10 o'clock, and doesn't start down until about 3 o'clock.
Yeah.
So when it starts getting cooler at night, then we know we're toward the end of it. But you know, I'm not anxious for summer to be over, but the heat's sort of wearing everybody out. I was telling you off mic that I saw a Facebook post. My wife was sitting there and she started laughing, and the Facebook post was, "Dear Lord, whatever you're cooking outside, it's done."
Yeah.
And it's like, yeah. So anyway, it is the South in July, so it can't be
South in July.
You can't say it's unexpected. So, and it's, you know, like I said, you manage to get through it. May have, like on Saturdays and Sundays, I probably go through a couple changes of clothes because you're doing something outside and come in for lunch and get, change your clothes and go back out and change your clothes again when you're done then. So, but it's no big deal.
But it'll cool off eventually.
We'll be complaining about the cold before you know it.
Oh yeah.
So, all right. Hey, listen. We talk about bulletproof estate planning on this show, and it's a call-in show.
Yeah.
I encourage people to call in with any questions you have or experiences that you've had that you want to share. If you want to ask a question that's personal, you can make it generic, sort of, don't use the names or maybe different numbers. But if you pose the same fact pattern, we can talk about that. So if you want to call in, the number is 931-766-9393. 931-766-9393 and ask a question. But coming up, I just had a seminar a couple of Saturdays ago over at the Star Theater in Pulaski. Had a banner turnout. Had about pushing 70 people. 65 or 66 showed up, and there's always some folks that don't show up, and we always have some walk-ins, right? And had a tremendous engagement rate and keep me busy for a while. But the next one we have is coming up on September the 20th, which is a Saturday again. Seems like we're doing almost exclusively Saturdays, and that's by popular demand. The weekday nights, a lot of folks have a lot of limitations on being able to make it you know, 6 o'clock on a weeknight. But I don't mind. But it's coming up on September the 20th, Saturday. We do those at 10 o'clock in the morning is when they start. It's called Wills, Trust, and the Nursing Home. That's pretty much what we talk about. And we're going to do it over here at WLX in your back, your building in the back, or the room in the back that you call the Country Cafe.
Yeah.
It's not a cafe, but you call it a cafe.
That's what they call it. Yeah.
But we're going to do that on September the 20th. And it's not too early to RSVP for that. We've already got signups for it. So, I'm not worried about, we will never cap out because it's a pretty big venue. So it's not like we have to worry about running out of space. One time we were there and we had enough people that we ran out of the tables. You know, you have those tables. And of course, you can't utilize the table when they're round. You know, we have these at the theater too, but you have these round tables, right? And if I'm giving a presentation with a PowerPoint, you kind of have to put chairs on the side of the table where people can see, because otherwise they got to turn the chair around to see, and the table's behind them now. And so we don't get as many people at a round table when the presentation is in one direction. Then you normally can. But one time we ran out of tables and just had to put some extra chairs up. But either way, we won't run out. There's plenty of room there. It's a nice big venue, and the air conditioner works, so that's good.
That's real good.
We have some light refreshments there. Miss Tammy will make some of her famous muffins that some people return over and over for, which is okay. Which is okay. If you like them that much, come on and get some.
Come and get it.
So,
Come and get it.
the worst thing we want to have happen is have a bunch left over.
Yeah.
That in a woman's logic, running out is like the worst thing that could happen. So I often tell people, when we RSVP for this, it's a very loose process. Just tell us you're coming and how many are coming. And we just want to have a head count for two reasons. One, we like to have enough tables and chairs set up ahead of time, so we're not scrambling doing it during and we do not want to know how many people are going to be there. The girls do not want to run out of food because apparently that's like the ultimate embarrassment or something.
I could understand
And
that.
I get
Yes.
it. I get it. So as a result, we make way more than we were expecting, and all the stuff has to go home. And if it's sweet stuff, I don't like where it ends up. But so we'll have some refreshments there. So it'll be fun. You'll like it.
It'll be fun.
And you'll learn a lot. I mean, you learn a lot at these presentations. I get a lot of great reviews on the presentations. People come to me and say, you know, I never knew some of this stuff was available. These are options I've never heard of. They sound great. I've been wanting to hear about this. I thought all I could do was write a will. I mean, just a whole plethora of comments that people have. Because if you come to a seminar, you're obviously giving this concept of estate planning some kind of thought. I mean, otherwise you wouldn't come at all. But if you come to it, you've been giving it some thought, and I'm willing to bet that you're probably procrastinating because you just don't know what options are available to you. And this will help that. Once you find out that there's options available, you tend to gravitate toward one, and now the procrastination goes away because you're a little more sure in a decision. And that's what procrastination is, when you're not sure of what you're doing, and so you're afraid to pull the trigger. So you just kind of put it off and say, I'll learn more about it. At least that's what I think. In this area, that's what it is. So come on to the seminar. I'll bring it up again at the end of the hour.
Okay.
So,
All right.
but I want to talk about something today that it continues to be confusing to folks, and I can see why. It's sort of a legal concept, but I'm going to thrash it out. But even though it's a legal concept, I hear people talk about it all the time, and people that actually do it. It's called when you give property away, or you're saving a life estate. Okay, and I've heard it called many different things: lifetime endowment, a couple of things but the technical term is called life estate, and it's an old common law form of action, so it's been around forever. But it's it's nothing wrong with doing a life estate. We still do those, but there can be some problems if you do it in conjunction with trying to prepare your assets for long-term care or protect an asset from long-term care, because I think what people's concerns are is I'm going to give away my house to my kids, but I'm going to reserve a life estate so I have a place to stay. Because if you're going to give a piece of property away, like your home, and you say I want to give it away so that if I go into long-term care, they won't be able to get at it, right? So if I give it away, the thought process is, if I give it away, then I don't have it for them to take. Okay, and that's not exactly true, and I'm going to unpack that a little bit. But let me start from the beginning and say, why would someone do a life estate in the first place? If you're going to give it away, give it away. But so if somebody gives away a piece of property that's their primary residence, the thought process, there's the what ifs that happen, like maybe who they marry, might be put some pressure on to give the boot. You know, so but it's risky. So if you came to me and, as an attorney and said, I want to give my kids the house and I'm just going to trust them to let me stay there, and I'd say, well, you know, there's risk there. I mean, I'm not trying to insult your children in any way, but from an attorney standpoint, there is just some risk there, because that can happen. You know, suppose you know your child says, I'll never ask you to leave, and then maybe that child predeceases you, and now the person left on the ownership is his wife, you know, and maybe the wife doesn't like you. Those are the kind of things we see that cause the problems, and you don't see that coming, right? So what people do is they give that property away, but they reserve a life estate. Now, what does it mean when you say reserve a life estate? Well, we got to get a couple terms straight. When you give there's two basic rights when you own a piece of property. Actually, there's more, but the two we're talking about. There's a future interest, meaning if you own your property, you know, you own what you can do with it in the future. It's kind of a weird concept. And you also own the present possessory interest, because you own now and you're living there, you're possessing it, right? I'm talking about your home, okay? So, but they're two separate rights, and so what you do when you give a house away and you give away the future interest, and that's called the remainder, sometimes the remainderment. And you give away the remainder, and you keep to yourself the present possessory interest, okay? And what that means is you don't own the property, but you own the right to live there for the rest of your life. And so now if somebody doesn't want you there, they can't kick you off. And it's even stronger than that. Suppose you give your house to your child and you reserve a life estate. And your house just happens to be somewhere next to the industrial park, and I don't know, DuPont comes along and they say, we want to buy that place there. Your son can sell that to them. But when they buy that, the life estate goes with it. They must honor that, because the life estate runs with the land. And so you don't have to worry about it. If you give it to your kid and they sell it, the new owner is going to give you the boot. Because the life estate's kind of like an easement, only it's an easement with a termination. And the termination is how long you live, or how long my wife and I live, right? And so this life estate, it's pretty strong, and that's what you're doing when you do it. You're reserving to yourself the present possessory interest. Now, if you go look at the deed is titled to the child, not to you, not the life estate holder. Now, if we want to think about this in terms of long-term care, here's what happens. People give the house away and they reserve a life estate, and they take the position, if I go into long-term care, they can't take the house because it's not mine. But it does cause some problems if you're thinking about, depending on when you apply for long-term care, because when you give it away, you have gifted it away. And now the question is, how much have you gifted away? And there's a way that they determine it. They put a value on the life estate and a value on the remainder. And you ask, well, how would they do that? Well, they have these charts in Title 42, which is the Social Security Act. Okay, and the charts are called life estate charts. And you go to the chart, and it has three columns. The column on the left is age. It actually goes to 119 if you can
Live that long.
Well, it goes to 100. Anyway, the column on the left is age, and then the other two columns, one's marked life estate, the other one's marked the remainder. And they both have a fraction in them, or a decimal number. And across any row, any horizontal row, those two decimals will add up to 1. So typically, people in our age group, if they would give a house away and we go to their age and go across, it usually hovers somewhere around, the remainder is 60%, and the retention of the life estate is 40%. They carry it to 6 decimal points, if you can believe that. Anyway, but let's just say it's right on the money at 60% and 40%. So what they're saying is, you actually gave away 60% of this house. So let's just say the house is worth $100,000. I know that's nothing but a Tobacco Road tar paper shack, but let's just use that number because it's easy to do in your head, right? So if the house is worth $100,000 and you give it to your kids and retain a life estate, they're going to view that as if you gifted away $60,000 and you held on to the other 40. So they put a value on the life estate, and it's based on your age. And now what they do is they take your age, and then they go to the value of the property that at the time you conveyed it, and the value they use is what's on the tax card. Not what it'll sell for, what the tax appraised value is. That's what they do. That's the number they're going to use as fair market value. And they're going to say you gave that away. So what people have run into, because they do this relatively soon before the care enters into the picture, right? Or they see care coming down the pike, and so they do this. Well, that the thing you gave away was the future interest, the remainder, okay? And you retained the present possessory right. And now they're gonna look at that as a gift, and you've given it away. It's gonna cause a penalty period, because you've given it and not got anything for it. You didn't get the life estate for it, because they're gonna say you retained a value of the property by doing that. Now, as you get older, that life estate, they use the tables, as you get older, the life estate gets lower. And the theory is a life estate expires worthless at death. So I mean, it gets less of a percentage and less of a percentage. So this way you give it away at age 65 and you live to 85 and they go down, it gets smaller and smaller. But a weird thing has happened, and that is, back in 2022 when the land prices were just going crazy, because they've jumped quite a bit up, now they've retraced a little bit, but the land values going up has offset the amount that those charts go down. And I've seen life estates that were valued the same as, and on a couple occasions more than what they were 10 years ago when they conveyed it. How's that for an unexpected problem? Anyway, so this concept of doing a life estate to think you're going to get out from under long-term care, it doesn't work. It could work, but you got to think of it in advance. You got to plan to do it so it does work.
Yeah.
So it's one of the things you can do. You don't have to give away the remainder. You can sell it. So just take the same scenario and you say, son, I'm going to give me $60,000 and I'm going to give you the land and I'm going to retain a life estate. And you can do that and you can sell it to him. Now he owns it. He just can't do anything with it because you're living on it. You're kind of like a lifetime renter. That you have a quiet enjoyment of the home. You can do whatever you want there. Yeah, other than commit waste is usually the way. You can't trash the place.
Yeah.
For the future interest owner's purpose, and so that's one way you can do it. Now if long-term care comes into the picture, the house is taken care of, but now they have the $60,000. They have the asset in money, right? Now the other thing you can do is either give it away. You can give it away, but remember whenever you give something away, we got this magic 5-year time period that's a problem. So you could give it away, and if you don't go into care for 5 years, then it's a done deal because they can't do anything about that. Because 5 years is as far as they can reach back to see if you've given anything away. And so we can. So, but most people that do it a little closer to needing care because they do it because they have a real anticipation that care is going to enter into their lives. So this life estate, it's a tricky thing. Now the question is, what about the value you have if you own the life estate? Well, there's certain things we can do with it. If you have a house when you go into care, it's called the primary residence, and it's treated different than any other real estate, and you can actually exclude it, which is a way to take it out of the equation. Well, they're going to treat the life estate the same way because it's kind of your primary residence that you have retained a right in and a value, something like that. And it gets a little squirrely from that point, but we can always deal with it. There's something to do with it. So, there's nothing wrong. I'm not saying don't do a life estate. A life estate is a very valid cause of action to do something if you want to retain the right to live in a place. It's just not, depending on when you do it, or don't do it haphazardly if you're doing it because you're worried about long-term care. There's a right way to do it. We can protect it all. But most of the times it gets done not right, and we either have to fix it. I got one going right now where the exact same thing happened. It happened back in 22, so we're still a year and a half almost out of the 5-year zone, but the person's in care and we're not going to be able to get the 5 years. So, and so we've already given it away, and it's interesting because the gift of the remainderment on that, it actually is right about, it's like $66,000, right at the $60,000 mark. And so what can we do about that if we're trying to get this person eligible? That's already an existing gift. They're going to calculate a penalty period, and the penalty period, if you calculate it, is going to be somewhere around almost 8 months, 7.7 months. And the house is practically the only asset the person has. So how are they going to private pay for 7.7 months if the only asset they have is the house? And they don't even have the house anymore. They gave it away and retained the life estate, right? So the kids are going to have to pay that private pay. And it's $10,000 a month. So it's a lot of money. And so what do? Well, there's a couple things we can do. The best thing to do would be to cure this gift, okay? So have the children there's a couple ways to cure it. You could just give the deed back. But that's not my favorite thing because I just want to deal with the $66,000. I don't want to deal with the whole $110,000, that's what this is. And so what we could do is just have them pay him $66,000. There's 2 children. They could pay the $66,000. Now they cured the gift part of it because that's the only part he gave away. And so they've cured that part of it, but now the applicant has the 66,000, which will over-resource him, okay? Now what we're gonna do is what we call a half a loaf for a Medicaid compliant annuity gift theory. We're gonna gift back to the kids 60% of that money, which is about 2/3, which is, about $40,000. Now that they paid $66,000 for it, they just got gifted back 40,000. Now they're only out 26,000. And then we're gonna retain the 6,000 that the person withheld and you turn it into a Medicaid compliant annuity that's designed to pay, coupled with his income, the exact cost of that 7.7 months. And so at the end of the day, we get the person eligible right away, because now he doesn't have any money. Because he gave away 2/3 of it and he spent the other third on the annuity. So it's gone. So he stays eligible. And because he has a penalty period, it gets paid, and it gets paid out of his money. The kids aren't paying it. And the kids end up with a house with a super cut rate, it's $110,000 estimated or tax value. Now they own the house for the cut rate of $26,000. It's a pretty good deal. Now, this particular case, the children don't really want to save the house. They just want to get dad eligible. And if dad were to pass away and just leave them the house, their goal was to sell it. Okay. Well, now it belongs to them, and it's out of the dad's picture. And now it belongs to them, and so what they can do, they can turn around and sell it for whatever they can get. They're only $26,000 into it. And so it probably, it's $110,000 on tax value, probably could sell for about $200. I'm just spitballing, but the tax value is always lower than what you can get for it. And so, maybe not that much lower, but I'm trying to use easy numbers. So they turn around and sell it for $200,000, they're $175 in the green. So there's things we can do. We don't have to just, if you did nothing, they have a 7.7-month penalty period that somebody in the family's got to pay for, because they can't let you stay if you're not paying. And I don't blame them. I'm not getting down on the facility for kicking people out. I mean, if you don't pay them, they don't have to provide the services. Because that's what it is. It's a service, right? They deserve to be compensated. But this way they get compensated, and it's coming out of the patient's money. But what we've done was we utilized the rules that are available to us, and we've maximized what we can keep and mitigated what we're going to lose. And so what we're going to lose is the private pay for that 7 months, but coupled with the income, it's only going to work about pushing $30,000 of his, and we get to preserve the goal of this house going to his children, which is what he wants.
Yeah.
And so there's all kinds of things you can do. It's just what you hear on the internet and what you hear people talking about sitting around the coffee shop. It's usually not right. I think there's some truth in some of it, but for the most part, it's not the whole story. Where I like to say it's not all there, at least, and it's completely wrong at most.
Yeah.
So that's why it's important, if you're in this situation, you need to talk to me or somebody like me. I'm not saying you have to talk to me. You find somebody that does this kind of work, and you talk to somebody that's got experience with those rules and long-term care eligibility and stuff like that. Because there are things you can do, you just never heard of them.
Yeah.
But they're there, and they're in the statute, which is why you never heard of them. Because first of all, I'm the only one talking about them, and two, you have to go read the statute to get it, and most people don't. I'm not faulting folks for that. I get it. And when the stuff that gets on the internet is just misinformation. Just misinformation, because they'll say give it away.
Well, but Stan, if it's on the internet, it's got to be
That's
true.
right.
They
That's
can't
right.
lie.
I think I mentioned this to Jeff or somebody. When I was a kid, I used to hear often that say, if it's in print, it's true.
Yeah.
So if it was in a book or if it was in a magazine or the newspaper, the presumption was it was true. Now, if I think about that, that's probably wasn't a bad presumption, because I think when people wrote books and magazines and newspapers, they tried to be correct and accurate. I mean, news reporting is not like it used to be.
Yeah.
Back then, it was definitely some fact behind it, right? Now, when you go to the internet, anybody and their brother can put anything on there. I could put a YouTube on there on the exact wrong way to fix a carburetor, right? I mean, and who would know until it's not policed, it's not double checked to see if it's valid. And if you look to see how to fix a carburetor, you'll find a dozen different ways to do it.
Oh, yeah.
So anything can be out there. And there's nothing that polices that to say this isn't correct, so it needs to be taken down or it needs to be fixed. So although along with easy information, you get a lot of it. And when you get a lot of it, you get, what's the best way to put it? along with the wheat, you get the chaff, right?
Yeah.
Okay, and it's hard to separate the chaff and the wheat because they look so much alike.
Yes.
Somebody else had something to tell us about that, but it was very important. So it's hard to separate the truth from the fiction.
It is.
And the only way to separate is go to the source, which is the law, you know, the 10 Care Act, and the other things that combine with it, all the things we've done since then to put in. And just so people know, yesterday, July the 31st, today's the 1st, right? Yesterday, Medicaid, which is the thing we're talking about, right? Medicaid is the federal act. Every state has its own version of it. Ours is called 10 Care. So Medicaid was 60 years old yesterday. It's 60th anniversary or birthday. And I swear to gosh, still don't understand it.
Still don't understand.
I mean, a lot of people still don't understand it. A lot of attorneys don't understand it. If you want to understand it, it's not like you can't understand it. You just got to put in the time to learn it. And that's where it lacks for people. Now I have, because this is all I do. And I do understand it. It doesn't change much. There's some changes. Like we talked here on the show a few Fridays ago about what the One Big Beautiful Bill did. And, you know, it didn't change it much, but there were a few minor things. But what it changed really didn't affect much of what I do. There's other things that 10 Care does that I don't do. Like there's a version. Some people say to me, well, 10 Care is welfare. Well, the answer to that's not exactly true. There's a version of 10 Care that's welfare. They have this under 65, if you're under 65 years old, and if you've already can show that you've got a qualified disability like SSI or SSDI or something like that, they will pay. They're like the payer of last resort, and they will pay above what you're already getting to get you to some sort of level of income, right? I don't even deal with that. I deal with what's called over 65 long-term care. Every once in a while, something comes along where I got somebody under 65 trying to get into care, and we dabble into that. But pretty much those boundaries don't cross in what I do. Now, and some of the changes they did make in the bill had to deal with the welfare end of it. They don't really call it welfare anymore. They used to call it welfare. Remember?
Yes.
You know what they call it now? SSI. You heard people talk about SSI.
Yeah.
I mean, I'm not trying to be insulting. I'm just saying that's what that's called now. And you know, it's folks that may be born with a disability or have a limited ability to provide for themselves, or sometimes no ability. And it's, you know, if you're in that category, those benefits are available. But like I said, I don't hardly ever deal with that.
Yeah.
Every once in a blue moon, I'll have somebody that goes into the nursing home and they're 64 or 63 years old. You know, and we have to do something special when that happens. But mostly, I'm dealing with the over 65 long-term care. And that is not a welfare program. That is not. You know, those are benefits that we're all entitled to. You know,
Paid into it ever since I started
that's right.
working.
I'm glad you said that because that's exactly right.
Yeah.
You know, I often will have somebody say to me, not often, but some folks, and they'll say, well, if I go in the nursing home and I rack up a bill, well, I always pay my bills and I feel obligated to pay that. And I think that's magnanimous. And I'm like that too. I have bills and I pay them all. And I don't like to not pay them. But, and I think that's a great philosophy. But the question I would want to ask first is say, on this particular bill we're talking about, like with the nursing home, do you owe it? I mean, you've paid for this all your life, right? And so now that you are unfortunate enough to need long-term care, why do you have to pay for it again? Because that's exactly what you're doing, you're paying again.
You are.
And so, you don't have to listen to my answer to this question, but how about we listen to the Supreme Court's question to this answer. And this has come up, and they ruled that Medicaid is an involuntary program. I never got a letter that said, hey, is it okay if we take so much out of your paycheck every week and put it towards expenses here, medical expenses? Did you get one of those? Asking permission to take money out of your paycheck?
I don't remember getting
it. Yeah, me neither. And you don't remember it because you didn't get it.
Oh, okay.
Your memory's not failing. You can't remember.
All right, you had me scared.
You can't remember something that didn't happen. And so that makes you an involuntary participant, okay? And the courts have said when you are an involuntary participant of a program, the benefits that it provides bubble up a little, rise to the level of an entitlement. Now, it's not going to the level of a right, which is very strong, right? And not even a privilege, but it's an entitlement. And you're entitled because you participate in it. Now, the program's designed, and the way this is worded in the statute, it's really kind of odd. This surprises a lot of people. But because this program is to take care of people in their advanced years when they can't take care of themselves or family can't take care of them, right? And so you have this entitlement. And they're saying, and so if you need this care, if you need to go into a facility that takes care of you, the statute literally says that what you're supposed to do is shift the burden, which is the cost, to the third party state. I mean, exact opposite of what somebody would say if they say, I feel an obligation to pay my own bill. You can pay your own bill and nobody will object to that, but the statute tells you that you have an obligation to shift the burden to them. Why? That's what the program is there for. And so you're entitled to this. Now, when we have this entitlement, and that sounds like great news, and it is, because it's not a welfare, it's not a gimme. You're entitled to these benefits, they're yours. If you need them, go get them. However, the courts have said, but it's an entitlement, but you still have to qualify. You still have to go through the eligibility rules and become eligible, because they're not saying anybody and their brother gets them. They're saying people get them that fit the income and asset limits that you have to have. And then, all the things that we do, like I just told you about that house, it seems like, well, that sounds pretty good. Is it okay to do that? That's not what I like to say. That's not 1 Pierchoski 14, that's not some chapter and verse. I didn't write that. That's in the 10 character. It tells us exactly how to do a Medicaid compliant annuity, which literally takes a countable asset and turns it into a non-countable stream of income. So we protect it. We just changed its posture from countable to non-countable. And when we do that, we protect it. And that's not my idea to do it. They define the Medicaid, thus the name, Medicaid compliant. You can do an annuity as long as it's Medicaid compliant. And I think I've mentioned it before, but since I brought it up, what are the compliant issues? Well, for one, it's got to be irrevocable and unassignable. Okay. Now, why would they say you can do this annuity, but you can't ever revoke it or assign it to someone? Well, I'll tell you why. What they're worried, you always have to think the way 10 Care thinks. And 10 Care always thinks about how can we keep you from screwing us out of the money we're supposed to get?
Yeah.
Okay. So if you did an annuity and you bought the annuity, which means when you bought it, you've given up the money and you got the stream of income now that's allowed, and then you get eligible for 10 Care. They say, okay, you're approved, you're eligible. After that happens, you could go say, hey, I want to cash this annuity out. Okay, just give me the lump sum. Now you're back to being over-resourced, and they wouldn't ever know that really happened. You know what I mean? So what they're saying is, you can never do that. You can do the annuity and protect the money. It's just that once you turn it into a Medicaid compliant annuity, it's irrevocable and unassignable. So you can't crap it out and take the lump sum, and you can't sign it over to your kid or something like that. And that makes sense for what they're trying to protect it from. So let's just do it. The other thing is a Medicaid compliant annuity has to be actuarially sound. You know what actuarially means? Is like talk about your lifestyle. They have these things called the actuarial tables. They've already decided how long we're going to live, LB.
Yeah.
We go to a chart and we look up our age and we go across and find male, because there's a chart for male and female, and you go across and it'll tell you how many years you're expected to live. Don't take that serious, but that's actuarially. Yeah. So if you go there and it says you're expected to live 10 years, the annuity cannot exceed the annuitant's actual lifetime expectancy. That's one of the compliant issues. The other one is they have to be equal payments. Each monthly payment of this annuity has to be the same amount. You can't get $10 a month and have this giant balloon payment at the end. Okay? Stuff like that. And that's pretty much there's a couple other small things, but that's pretty much the compliant. And those are not too hard to live with. And so it's a tool we use a lot. So trying to think of how I got into the Medicaid compliant annuity. I kind of forgot. Well, it took me there. Have my own senior moment. But anyway, the point is there's lots of things that can be done on all these things. So I'll often say I can never have a case where I can't come up with something.
Yeah.
Somebody comes to me at the right time, I can really work some magic.
Yeah.
Somebody comes to me at the 11th hour, they've already filed a do-it-yourself application, they've denied it for whatever reasons. I can usually find something to do. It's usually not the ideal result because I'm dealing with things that have already happened, but I can still do something. You know what I mean?
Yeah.
Vis-a-vis this case I just talked about where the house has already been given away. It was 5 years ago. Now what are we going to do about it? The worst thing we can do is to do nothing and let it just be a standing penalty period, because who's going to pay it?
Yeah.
And if the kids can't pay it, then you just don't get the care.
Get it.
And that's not the good place to be either.
No, it's not. Well, Stan, I hate to do this, but can we take just a little break here?
Absolutely.
I need to,
Are we broadcasting?
Yeah.
Oh, okay.
Well, I'll tell you what, I will...
How about somebody call us, let us know they're hearing us?
Yeah, there you go. Tell you what, I'm gonna play this and then I will be right back.
Okay, let's take a break.
And take a little break. Well, I said I would. Oh, I know. All right, here we go.
Need me to come push the button for you? We usually do that. We usually do that up front. Okay. ZZ Top, but that's the chart today.
Apologize for that, but you know, I've got a question, Stan.
Got it all fixed up. Yeah, question, please.
You have a lot of, hear it on a lot of advertisements, especially on Fox News, about these people that illegally come in and take over your property.
Oh, okay.
And is that factual, or is that just?
Well,
I don't understand how it can happen.
let me put it this way. I don't worry about it too much.
Uh-huh.
You know, I can see the logic behind it, but I think it's very difficult to do it. There's so many checks and balances. I'm not sure how you can, because first of all, here's the way it works. I mean, they don't steal your home and kick you out and go live there. You know what I mean? They don't want anything to do with your home. What they do is they steal the title of it, or here's the theory. They can steal it, if they can show that they have title to the home, then they can take a loan out on the home. And then, of course, the loan gets applied to the, one thing that gets me is how does the loan gets put on the house, and the theory is that now the homeowner that doesn't know this happened is subject to the loan. You know, if you retitle the house to the person scamming you, the deed is an integral part of a loan on a piece of real estate when you're using that for collateral. You know, and I don't see how it's going to end up with the previous owner that you just removed. You know what I mean?
Yeah.
So, but you can use a piece of property for collateral. I think the theory is if that's collateral, then of course they don't pay the loan back, they just get the loan, take the money, and take off. and then they turn to the homeowner, or the previous homeowner now, for paying it. And it may be a real thing, I've never seen it, nobody's ever come to me and said it's happened to them. I don't know anybody personally. I've seen the commercials, they're pretty cryptic, they don't get into too much, but I have, as far as the services that people sell, like LifeLock or something like that, and there's maybe a couple other ones, where they monitor this, okay? I have had scenes, I've seen in I've looked at 3 other states around us, not Tennessee, but their attorney general for the state, they often write opinions about stuff. And I've looked at 3 of them for attorney opinions about those services. And they weren't very positive about them. It's not that they don't do what they say they do. Don't get me wrong. It's not that I'm saying it's a waste of money, they take your money and they scam, but it's what they're doing doesn't help. It's after the fact. In other words, they will let you know if your title's been stolen. Well, at that point, you know what I mean? It's been taken, and there's not much to do about it. I guess if I think about it hard enough, that you possibly, if you know that happened, you might be able to mitigate it. Because on the commercials they say, you know, months go by and then the person finds out they've got 3 mortgages on the house. I mean, maybe if somebody can mortgage it more than once, there might be some ability to not that it happened more than the first time. But I still struggle with it. You know, like I said, I've never seen it, but I have looked at it in terms of when we do trust. And when we do trust, we usually title the home to the trust. Now, in order to do anything with that home that's in a trust, now you have a certificate of trust that shows that the trust owns the home. It's another level of stuff they have to get past. And I'm telling you right now, when we have people that sell homes in a trust, I mean, it's easy to do, but most of the times you get involved with a title insurance company that wants to see the trust, and sometimes they want to see some sections of the trust because they want to make sure that the trustee is the person that has the authority to sell the home. And even though it says that in the certificate of trust, they'll sometimes want to see the excerpts in the trust that say that, to guarantee that they're the person that has the right to sell it, because they're insuring the title. And if it's not proper, then they could have a claim come up. So it's another level of stuff. So I don't see how it gets done in the first place, but I really don't see how it gets done if you throw that in the mix too. Good question, and if you don't understand it, it's for good reason. It's not, when you try to walk through the actual logistics of it, there's some steps that are missing that I just don't see how it can happen. So, and then they talk about saying, oh, they do this document and then you just go to a notary and get it. It's approved. You know, the notaries don't catch it. Well, that's not what a notary does.
No.
Notary is a very specific thing. Notary just, if you come to me, say I'm a notary, and you come to me and say, Stan, would you notarize this? I say, sure. And a lot of times I'll ask for your driver's license, right? And then I'll notarize it. All I'm doing, I don't care if you bring me a 1-page document or a 1,000-page document. I'm not looking at the document. I'm not approving what you're doing. I'm verifying that you are who you say you are. Okay? Now, anybody can do that, whether you're a scam or not, but when you do that, you're identified. So then what they're trying to say is that they will forge your signature, the owner of the home, and then get it notarized. Have some notary mistake you for the person that's supposed to be there. Now, I know some notaries are a little lax on that kind of stuff, but they're not supposed to be. And that's why the language says, who is known to me or provided satisfactory proof that they are who they say they are. And, you know, I often hear people say, hey, my daddy passed away and he's got a will and everything. I got it right here. It's notarized and everything. The will doesn't need to be notarized. The statute is very clear on that. It needs to be witnessed, not notarized. Notary does nothing. It's defective. And sometimes I'll tell people, I see your dad's handwritten will here, but it's defective because it needs to be witnessed.
So if somebody had, like wrote up their own will and had it notarized, but didn't have witnesses on it, that will is...
Well, it depends whether you write it up or type it up. If you type it, let's say you type it up, it needs to be witnessed. Okay. Now, when we do a will, we have a self-proving affidavit that the witness has signed and is notarized, but not the testator, not the person doing the will. The will itself needs to be witnessed by 2 people, and it goes even further. It has to be in sight and presence of each other. If it's not, the will fails. I get a lot of flack. We do in every trust plan we do has a will, and it's called a pour-over will, and then some people just want the regular last will and testament, and we go through a process, and I can see people smile and smirk. They think it's silly, and I kind of have to tell them, hey, I have to do this or something. But the statute says what I have to do, what it's called a formally executed document. The formalities are, I have to say, you have to purport in the sight and presence of the two witnesses, that this is your last will and testament. So I asked the question, you know, you are purporting in the sight and presence of two witnesses, which are myself and Miss So-and-so over here, that this is your last will and testament. Is that correct? And they have to say yes out loud in the sight and presence of the two witnesses. And they have to report their sound mind. They have to purport, and they have to be signing it in the sight and presence. And the witnesses have to declare that they've heard the person say it's their last will and testament. If you don't do any of it, if you miss one of those, when the courts look at wills, it is what I call strict compliance. If there is even the slightest thing wrong with it, it's an invalid will. There is no close enough. A lot of people say, well, he signed the wrong page, you know. Well, that's fatal to the will. Or he didn't say that. He didn't make that speech. It's fatal to the will because they say what the legislature said what the rules of a valid will are, and that's what they follow. And they're very strict about it. I've seen things that were just a crying shame where somebody did a will and did exactly that, signed on the wrong page. And the page they signed on was the self-proving affidavit, which is not part of the will. And the analysis they said was the signature has to be on the will and witnessed by two people. Well, his signature was blank, but on this self-proving affidavit, which the person writing the will is not supposed to, has anything to do with, he signs on there. And they said it's close, but it's not good enough. It doesn't meet the statute.
Yes.
That's why I'm not a big fan of will. If you come to my seminar, you will hear me beat up on wills. I mean, I'll say, just come right out and say it. I'm biased. They're a hassle. They don't do very much. They're probably a step in the right direction, but that's about all. They're formally executed. They're easy to challenge. When you challenge them, the probate court must entertain the challenge. I mean, they're not my favorite instrument.
Yeah.
But for some people, it's a fit, or that's just what they want. But I'm saying, that's why I beat up on them. There's a better option. The trust plans we do. But to answer your question, you have to sign it. Now, I don't know if I have time to get into it, but you said if somebody writes up a will, there is something called a holographic will, which is all in the testator's handwriting. Or, the statute says all the material provisions are in the testator's handwriting. So, now, when you do that, you can do that, and that has to be witnessed too, but there's some slack on the witnessing of that, okay? Because sometimes people, and then they have a third one called a non-cooperative will, which is really like a deathbed will.
Yeah.
You know what I mean? You're dying and you just pencil something out. That one, you just have to prove the signature by people within a certain amount of time. They have to come and say, yeah, that was his signature. They don't have to be there. But this sight and presence thing, you think about it. I've seen some lawyers put in wills sight, presence, and earshot. Although it doesn't say you have to have earshot, but it does say sight and presence. So, could you be in sight but not presence? I guess so. Let's say we were in the front room and where WLX is, and we were signing a will. And one of the witnesses is sitting there with us, but the other one's over standing in front of the state police building. He's within our sight, but he's not in our presence because he can't hear what we're talking about. He doesn't know what's right. I mean, but how about, can you be in the presence and not the sight? Okay, suppose we're doing it in this little room right there, but the other witness is on the other, is around the corner and can hear everything we're saying, but he's not in our sight. I mean, these are the rules. If you think they're stupid, then don't do a will because because if they think they're stupid, you must comply with them or your will is invalid. Yeah. I've seen it happen so many times. It's just a shame. I saw a will one time that the courts looked at, and I could almost see the court's tears on the opinion because they had the rule invalid. And it's like, I can't imagine any lawyer let this thing through. This is what I was talking about. It was a will, it was pretty well written out, dressed a lot of stuff. And at the last page, you have the testator's signature, okay? And then the witnesses. The witnesses signed it, his signature was not there. Now, the next page is a self-proving affidavit that the witnesses sign, swearing that was said, what I said, the stuff I say was said, and swearing that we're doing those things that I said, like we're all in the sight and presence. But that has just to do with the witnesses, okay? And the signature of the testator was on that self-proving affidavit, which is not a part of the will. And they analyzed this, and like I said, you could just hear them trying to make it work, but they said, listen, statute says he has to sign the will, the instrument. And this document is not a page of the instrument, it's an additional thing for an additional purpose. Why do we have a self-proving affidavit of the witnesses? Well, suppose the witnesses pass away, and somewhere in the future you need to prove the validity of the will. Well, if you're alive, they'll subpoena you to come in and they will ask you those things I just said. Were you there in the sight and presence? Did the testator say this was their last will? Did they purport being in sound mind? And did they sign it while you were sitting there looking at it? Well, I'd answer all those questions, there's 5 questions, I'd answer them all, yeah, right? But if I was already predeceased or you couldn't find me, then we subpoena in the affidavit, which has the answer to the 5 questions, and we're allowed to, that's evidence in court saying that so I'm testifying in court way before I ever show up in court, and even if I can't. So that's what that thing does, so it's a completely different purpose. It's a self-proving of what happened. And they said that his signature was not on the instrument, therefore it fails. And if you look at this, there was a pretty big estate. There were, because those are the kind to make it to court. You know, you don't get to court unless you've got a lot of money that's passing and everybody's getting upset about their share and stuff like that. And so these people wanted to invalidate the will, and they took it to court, and the court had to rule it was invalid because in technical theory, he didn't sign the will. And so it's a shame.
Yeah.
It's a shame. They went, somebody needs to be sued for malpractice on that one.
Yeah.
Because I can't imagine that getting past the lawyer. But somebody did, and then, but anyway, wills are a tricky thing. Sometimes I do a whole hour on the 3 different kinds. There are 3 different kinds. The third one, the deathbed will, is kind of useless because you can do it, but it's limited to $1,000 of personal property. I mean, you can't pass any real estate, and you can't pass more than $1,000 of property. So I mean, really, it has little to no use.
And another thing, when you're doing something like this, I may get in trouble for saying this, but I'm going to.
Okay.
All right, if you're doing a will or trust, you don't want to go to a criminal defense lawyer and get him to draw up you a will or a trust. You need to go to an estate lawyer. That's all they...
You know, I used to be a criminal defense lawyer.
I know you did. But, now then, you do nothing but state law.
I mean, it's a different area of the law, so it has
Yeah.
different rules. It's something you got to be familiar with it. And it's like the same old thing. A lot of attorneys, we don't do phone book anymore, but when you look in the phone book or their ad somewhere, there'll be a list of all they deal with. And it's a lot of things. And, maybe they can do all those, but my experience is if you have 20 things you do, you're not going to do any of them well. If you kind of hone in on a couple areas of law, you can do those much better because it's sort of your focus. We're not allowed to say specialized, but if that's what you're doing, just focusing on that, and that's kind of like me, that's all I do. Yeah. Now, estate planning is more than just wills, it's trust, it's some of the stuff that goes with that, but it's not all the other stuff. It's not personal injury lawsuits, it's not criminal defense anymore, it's not immigration law. It's just hard to do everything.
It'd be like somebody going to a TV station and learn how to be a radio disc
Yeah, that's right. That's right. Or at least how to. Of course, when you're radio, you don't have to look good.
No,
you just have to sound good.
Well, when you do
now
like
on this one, you have to look good. Which means people were watching me jive to the ZZ Top song you played, right? That's a good one. So, all right, so we're coming up on it. So, just want to go over my seminar again. And of course, if you want to call me and talk to me about anything we talk about on this show or anything estate planning, just call my office at Pierchoski Estate Law, Pierchoski Elder Law. The number is 931-363-7222. And I had the gentleman in my office yesterday who said I didn't say the number or said it too fast. Here it is again. It's 931-363-7222. We're right on the square in downtown Pulaski. Or you can go to my website, which is Estate Plan Stan. You can get my phone number there, or you can email me a question. If you're interested in coming to the seminar, it's September the 20th at WLX radio station. The physical address is 1212 North Locust Avenue in Lawrenceburg. If you're not familiar with it, GPS will bring you right here. At the back of the building, what they call the Country Cafe. I hate to say that because there's no sign that says Country Cafe.
I know it.
And I had one person say, we'll just stay afterward and have lunch. I said, it's not really that kind of cafe.
It don't work that way.
But if you want to come to it, we call it Wills Trust in the Nursing Home. We do it at 10 o'clock on a Saturday. I think you'll really enjoy it because we talk about a lot of stuff that will be new to you. Just keep an open mind and let it flow. And I think you'll really enjoy it like everybody else does. So, and bring questions.
I went to one of the seminars that you had here. I didn't get to hear all of it, but what I heard was, very informative, very...
If you're worried about this long-term care issue, there's a solution. It's called the Asset Protection Trust. There is a solution to this problem. So,
and that's something else. If you're thinking about it, don't think about it. Just go ahead and do it.
Or at least get educated. Come to the seminar, and you'll learn more than you can ever learn on the internet.
Yeah. So it's there's more to it than just signing a piece of paper. But it's.
Now I know the clock behind you is a little bit off from exact. So whatever your radio says, I think it's about 20 seconds off. So
well,
if we need to wind up,
they need to fix that. I need to talk to management. Jeff Hood is slacking on his job. He
Yeah,
needs to make sure that that's right.
So he had to run out, I heard. I was listening on the way
Yeah,
over.
he had to.
He had to take off.
I'm not sure what he had going on, but every once in a while he's got something that.
He actually has a life other than radio.
Oh yes, he does. He does.
When we get talking about this, he gets involved in the real estate issues.
Yes,
because that's right down his main street.
And he knows it. Well, all right. Thank you, Stan.
Okay, we'll see you next Friday.
Vacations.
The job market is
I'm
cooled
so
off.
sorry I had to go
Big
to that
time.
thing, but
I'm Dave
I kept
Anthony.
thinking to
Fox
myself,
News
I
has
can
been a
make it.
lot
I can
less
make it.
hiring the last 3 months. Fox's Ginny Casola has the numbers this morning.
I can't believe they're honing in on the fact that the job estimate was a little bit